That's good.
All right, does everyone have a worksheet?
Yeah.
It says mock motion suppress hearing. At the end, you can hand this in. Actually, the way it worked out last time is people actually end up getting caught up. And if you don't finish it, that's fine. Fill it out and hand it to us next class. Today, we have the honor and privilege of having three of Cape Cod's most eminent legal experts come to share their time with you and to play out a mock motion to suppress hearing. And the idea being that in observing this, you will get to know the law in a way that, by merely us talking about it, perhaps will not be quite as direct and relevant to you. So we have Assistant District Attorney Ned Lynch from District Attorney's Office. We have Defense Attorney Robert Hofmann and Superior Court Judge Robert Rufo, who I will turn the floor over to. Thank you.
Thanks, Mr. Dickson. Good afternoon. I have said this each and every year. I've been here now 5 years in a row, and I came because I was so impressed with Mr. Dickson's government students when I encountered them back in 2008 that I asked him if I could come and do a little scenario, and it's kind of developed each year to myself coming back, and I've had the pleasure of having Assistant District Attorneys like Ned Lynch and Defense Attorneys like Rob Hofmann, who do a fine job each and every day. Working up at the courthouse in Route 6A up in Barnstable Village, they are Superior Court ADAs and defense attorneys, because as you know, we have a district court system and we have a superior court system, and not that we're any better, but we have more serious cases where people who are committing crimes are facing possibility of incarceration in a state prison, as opposed to the House of Correction up at the Otis Air Force Base, where Sheriff Cummings runs the Barnstable County Correctional House of Correction and jail. So what we're trying to do is expose you to a little bit of what we call a pretrial hearing, where subsequent to a police encounter, which in this case is a house party situation that developed into an arrest, the police activity is scrutinized within the context of what we call the Fourth Amendment. And you're all experts in the Fourth Amendment, Mr. Dickson tells me. Are you? Let me see who's an expert in the Fourth Amendment. You are? What's the Fourth Amendment?
The right against unreasonable searches.
That's right. Absolutely perfect. The right to be free from unreasonable searches and seizures. Now, we're talking about a house, and a home is a person's, a place of sanctity where the police cannot come into a home normally unless they have what? What do they need? A warrant, yeah, a search warrant. And you get a search warrant by going to court in advance of an intrusion, a search, and asking a judge or a clerk magistrate after hours to issue the search warrant based upon what? What's the two words? Probable cause. Very good. So probable cause is the foundation upon which the police have to show by way of affidavit and facts and circumstances to justify the intrusion. So what we're going to show you through this little scenario, with Mr. Dickson being the police officer, is an examination by ADA Lynch of his officer who conducted the arrest, if you will, of the events leading up to the arrest, and then cross-examined by the defense attorney, and then I have to make the call as to whether or not this is an appropriate, if you will, exercise of police authority. Because we all have rights guaranteed to us under the Constitution, right? But we also have responsibilities to act in accordance with the laws that we are bound to act by as a law-abiding citizen. So this situation is not unlike things that I would see during the course of a regular day or a week, where these motions to suppress, trying to keep the evidence out at trial, are filed by the defense. When they're filed by the defense, the burden shifts over to the Commonwealth to show that the police action, in this case entering a person's home, was appropriately conducted in accordance with the case law that has interpreted the Fourth Amendment to the Constitution of the United States. So that's, in essence, in a nutshell, what we're trying to show you. We'll do that, and then we'll take some questions. And I need your help to decide this one, because it's a closed case. All right? So, ADA Lynch, do you want to call a witness? Yes. Officer Dickson. So, Officer Dickson, sworn, do you solemnly swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Okay.
Sir, could you state your full name and spell your last name for the record?
John Theodore Dickson, D-I-C-K-S-O-N.
And who are you employed by?
I'm employed by the Harwich Police Department.
In what capacity?
I am a detective in the department. I've been a detective for 8 years, an officer for 20 years.
Turning your attention to last Saturday night, were you working for the Harwich Police Department?
I was indeed.
And were you out on patrol in the area of Depot Road?
I was.
And at some point in time, were you dispatched to a complaint?
I was. We dispatch relayed a noise complaint to me on Depot Road.
Okay. And who called in that complaint?
A neighbor, I don't recall the name of the neighbor, but and also another resident on Depot Road.
Were you the only officer to respond at that time?
I was actually one of, well, no, I'm sorry, yes, I was the first one to respond to it.
Okay.
So at that point, I was the only officer to respond.
And you were a marked cruiser?
I was in a marked
In
cruiser.
uniform?
I was in uniform.
And when you arrived at the area of the address, the residence, did you make observations of any noise?
Yeah, I stopped the vehicle and pulled over on a side street in the vicinity. And turning off my vehicle, I heard loud noises consistent with a party going on.
How far away were you?
It turns out, once I were able to locate where it was, I was about 200 yards away from the home.
So when you heard that, what did you do?
I then approached the home, and then it was at that point that once I determined which home it was, that I called for backup.
All right, and how many officers came?
There were a total of 3 officers.
And how did they present themselves? Were they in marked cruisers?
They were also in marked cruisers.
And were they in uniform?
They were also in uniform.
Now, when you got to the residence in question, did you make observations of the outside of the residence?
I did. Outside the residence, there were a large number of vehicles parked along the side of the road, parked in the driveway. I would estimate about 10 vehicles.
Did you look at the license plate and make any determinations as to who these motor vehicles belong to?
Yeah, these were vehicles that were familiar to us, vehicles we would see parked at the high school, vehicles that on previous traffic stops are ones that we knew were driven by minors.
Now, at that point, what did you do?
At that point, the 3 of us approached the home and knocked on the door and knocked and announced, and the Harwich Police Department, please open the door.
What happened next?
It actually, at that point, it was very loud, but as having knocked very loudly, the home became quiet.
What do you mean?
In that we heard music and voices prior to that, and after knocking in loudly and announcing Harwich Police Department opened the door, the music was turned off and we stopped hearing any voices.
What was the next thing that happened?
At that point, we waited for a while to see if when we repeated our knock and announce, and after, I would say, 2 minutes of no response, we decided to enter the home.
Now, when you say 2 minutes of no response, was it that you could not hear anything occurring inside the house?
We did not hear anything occurring in the house, and there was no response to our second knock and announce.
And after that period of time, how did you enter the house? What did you do?
We turned the knob, the door was unlocked, so we were in turning the knob able to enter the home.
Okay, and were you the first person in?
What's that?
Were you the first person in?
I was the first person in.
Okay. Describe what happened.
As we entered the home, there was a hallway, and at the end of the hallway was an open room, and in this open room there were a large number of people as we walked in.
So when you entered the home, you opened the door and you positioned yourself in the hallway?
Yes.
Right. And did you walk down the hallway?
We walked down the hallway.
And you were the first officer?
Yeah, and actually, soon once we're in the hallway looking forward, I could see 1 or 2 people in the room down the hallway, and so we proceeded down the hallway into that room where they were gathered.
Did you recognize them?
Large gathering.
Did you recognize the people that you saw?
Yeah, these are kids that were familiar to me from having seen at the high school, say at a high school basketball game or event like that, several of which I've done.
And you made observations of these people before you made your way down the hallway, correct?
Yes, I did recognize at least one of them prior to entering them.
So when you made your way down the hallway, you say you opened up into a larger room?
Yes.
What did you see?
At that point, there was a gathering of approximately 20 young people who some were standing, some were sitting. A couple of people, once we entered the room, ran out. There was a door to a back patio, and they ran out. A couple of people ran out that door.
Okay. Now, did you make any observations of them concerning any sort of impairment?
Yeah, they were in our. They were unstable. They were stumbling. The persons who ran out the door were sort of tripping as they went. Other people looked like they perhaps would try to do so but they seemed to be impaired by alcohol.
Objection. I'm going to sustain that objection.
Did you make any observations of alcohol at that time?
At that point, we did not see any alcohol in their room.
Okay. Now, based on the things that you observed concerning these individuals, did you form an opinion as to whether they were under the influence?
Yes, I did form an opinion.
What was the opinion?
The opinion was that they were clearly under the influence.
And you indicated a few kids ran off.
Yeah.
At some point in time, were officers positioned near the front door? Or I should say the back door?
Yes, at that point, as the three of us entered, it was actually Officer Davis moved towards the back door in order to discourage anyone else from, well, prevent anyone else from leaving out of that door.
And was that done?
That was, yes.
Nobody else left?
No one else left.
Now, what was the next thing that happened?
The next thing we did an initial search for what's in the, well, I'm sorry, first we asked everyone to take a seat in that room, and they all sat in that room, some on chairs, some on the floor. And then we did an initial search, and visible from that room, but just scanning into the kitchen and the dining room area, which were separate from this, there were quantities of alcohol that were visible.
Now, what was the purpose of this initial search?
Initial search was to see if there were other persons in the neighboring areas, or just to scan what other potential dangers might exist to us and to the people involved in these neighboring rooms.
Okay, and so you described them as several adjacent rooms?
Yeah, open doorways, open archways, not closed rooms.
All right, so when you entered this room, how did you search the room? What did you do?
The main room or the side rooms?
The side rooms.
The side rooms, we visually scanned them from the main room, and then seeing alcohol present, we did then go into those rooms, and we didn't find additional alcohol other than what was visible when we do so. I mean, there was, I think there was one room we found 2 cases of beer, and the other we found several open bottles of liquor.
Now, by the way, the individuals that you detained in the big room, there was an investigation as to their ages?
Yes, we did ask them for identification, and all of them did have identification on them, and all of them were minors.
And this was before you went into the adjacent room, correct?
Yeah, indeed. Yeah.
And at some point in time, was there any request that the owner step forward?
Yes, we did ask whose home this was. At the same time, we were asking for IDs, and one person did step forward.
Now, besides finding alcohol, was there anything else found in the house?
After finding the alcohol and determining the impairment of the individuals in the room, we did seek to whether there were other individuals in the home who might be unconscious and might be in peril. And so we did a protective sweep of the house, and there was one additional bedroom on the first floor that we searched, and then going up the stairs to a second floor, there were 3 bedrooms in the second floor that we also searched to see if there were any individuals who might be in difficulty in those rooms.
And what did you find?
In one of those rooms, there was several pieces of drug paraphernalia that were visible in one of the rooms.
And where in the room was it found?
Right in the middle. There was right in the middle. There was, I think, 2 bongs and a pipe.
And was there anything else found in that room?
In finding the paraphernalia, we did do a look through the room and to see what else might be in that room, and in a partially open a drawer, we did find a quantity of marijuana.
And was that marijuana eventually tested and determined to be marijuana?
Yeah, it was tested, determined to be marijuana, and determined to be 1.5 ounces of marijuana.
And that was secured?
That was secured, yes.
As well as the alcohol that was found earlier?
Indeed.
Now, did something else occur with regards to individuals leaving the house?
Yes, at the stage that we were doing a protective sweep, 2 people did leave the house out the front door. So I think we had Officer Davis was still in the main room observing, and near the back door while Officer Mitchell and I were doing the protective sweep. And but at that time, 2 individuals did leave the front door from the main room.
And what happened then?
As they left, they entered into one of the vehicles at the car and began to leave. And it happened to be just as Officer Harris was also responding to it, and he happened to pull right up to them just before they left the driveway. And seeing them leave and knowing the situation, having been in communication, he put his lights on, he stopped the vehicle.
Well, I'm gonna sustain it. You can't testify as what another officer did.
Okay.
Next question.
Were you present when these individuals were field tested for sobriety?
I was not present when the vehicle stopped, but I was present when they were field tested.
What happened?
Both of the occupants of the vehicle clearly failed field sobriety.
Was it determined who the operator was? Was there any statement in that regard?
The operator of the vehicle?
Yes.
Yes, that was, one individual was the operator, one was the passenger, but they were both clearly intoxicated. And I apologize, I think that the field sobriety test was only done on the individual who was the operator.
And was there a breathalyzer given?
A breathalyzer was given.
And to the
Oh,
person?
no, I'm sorry, no, in this case, the driver refused the breathalyzer.
Now, at some point in time, was there a statement taken from at least one of the occupants concerning the individuals that had run earlier?
Yes, we interviewed the people and asked them specifically, did they, the names of the individuals who had left, and we had from two individuals gave us two names, and so we seemed to have a confirmation of those two names.
And was that statement obtained inside that larger room inside the residence?
Yes.
And at some point in time, did you take charges out against these individuals that were involved in this incident?
Yes, at the end of, at this point, after Officer Harris arrived, we did arrest all of the individuals. There were 18 individuals there as minors in possession of alcohol, and we did also seek charges against the two individuals who had fled the scene.
And with regards to any charges concerning OUI?
Yes, and there was the operator of the vehicle was charged with operating on the influence, and also the owner of the home was, the resident of the home was charged with possession of marijuana.
So that was eventually determined by the police?
Yes.
No further questions?
All right. Attorney Hofmann, cross-examination.
Thank you, Your Honor. You responded to a noise complaint,
Yes.
and you got there shortly after the complaint was called in, right?
Yeah, within 5 or 10 minutes, yeah.
And when you got there, you pulled your car over and shut it off,
Yep,
and you could hear loud noise.
yes,
And it took you a minute to figure out where it was coming from, but you knew it was coming from that area.
yes,
And eventually you approached the house.
yes,
It was still loud
yes.
at that time. You called in a few other officers, is that right?
We had two other officers respond, and so I did call for backup prior to approaching the house.
And when you knocked on the door,
Yeah,
the noise stopped, right?
yes, after we knocked and announced, the noise stopped.
Okay. And at that point, just let me back up for 1 second. A noise complaint is not a criminal investigation. A response to a noise complaint is not a criminal investigation, is it?
It is a violation of the town's bylaw.
In other words, I guess you could get a ticket for it, right?
Yes, you could be cited for that, yes.
But the more common practice would be for the police to knock on the door and say, please be quiet, right?
Yes, if the only issue were the noise emanating from the home, it would be the common practice would be to alert the homeowner of the complaint and ask them to turn to end the noise.
Okay. And the purpose, in other words, for the police to get involved in a situation like this is to put a stop to the complaint that originated through another citizen, right?
The purpose of responding to a noise complaint, yes, is to end the source of the noise which is causing the complaint.
And after you knocked, the noise stopped.
Yes,
Noise complaint over, right?
yes.
And you waited around for a couple minutes?
We did. We knocked again, and knocked and announced the second time after the noise stopped. And we still again we waited for a response from that second knock and announce, and we did not get a response.
Okay. At that point, there is no evidence of any criminal activity whatsoever going on inside that house, right?
No, I would say there was evidence of criminal activity in the presence of a large gathering of what are known to us as minors in a situation where on a Saturday night where large noises were emanating from home. So I think, as an officer in my experience, that is evidence of criminal activity of minors in possession of.
All right, let me step you back. First,
Okay.
I'll ask you one question first.
Okay.
You didn't see any alcohol, right?
We had not seen any alcohol.
Okay. And the noise complaint had stopped.
Yes.
And the cars that you saw, you recognized to be cars that belong to minors.
Yes,
Certainly, there's nothing illegal about a group of minors gathering together, right?
indeed.
And after you knocked and announced, there was no answer.
Yes,
Still no noise.
still no noise.
And so you opened the door.
Yes.
When you opened the door, you didn't call in, is anybody home, did you?
No, we opened and
It was a
entered.
yes or no question, officer. At that point, you stepped into the hallway, right?
Yes,
At that point, you saw a couple of people in the room further up, right?
yes.
You didn't say, excuse me, please come over here and talk to me?
No, I didn't.
No, you went right on into the house, didn't you?
Yes,
You and the other officers,
yes,
with your badges
yes.
and your guns,
We were carrying weapons. They were not drawn.
and you went into the dining room there and you saw about 20 people around.
Yeah.
Now, you said you saw some people that were intoxicated. There's some stumbling and some tripping and stuff like that.
Yes.
You didn't see anybody vomiting, did you?
We did not see anyone vomit.
Nobody unconscious laying on the ground or anything like that, right?
There was no one unconscious in that room.
You saw, in fact, a couple of people run away, right?
Yes.
Now, you positioned an officer at the door to prevent more people from running away, right?
Yes.
Now, it's important that nobody's under arrest at this point, right?
No one had yet been placed under arrest.
But you were making it very clear to these kids that they could not leave, weren't you?
Yes.
Now, at the point that you saw these kids intoxicated, you were claiming that you were very worried about these kids. You needed to make sure everybody was okay, right?
Yes.
You didn't call the paramedics, did you?
We had not, none of the individuals had presented symptoms to us that would have required immediate medical attention, so no, we
So
did not
you
call.
didn't see an emergency,
Did not see an emergency medical situation, no.
okay? And did you ask anybody if there was anybody else in the house?
We did ask if there were other people in the house.
And they said
They said no. They said there were not other people in the house.
there was nobody else in the house. In fact, there wasn't anybody else in the house, was there?
After a protective sweep, we did determine there was no one else in the house.
Okay. So at this point, though, you determine that you just want to make sure. You want to be sure that there's nobody else there and that there's nobody in trouble in this house, right?
Yes,
And you say you do that just by looking into the rooms just to make sure nobody else is there, right?
yes.
And you see all this alcohol.
Yeah, in the, visible from the room we were in. I mean, it was simply just in scanning our surroundings, we saw the alcohol in the kitchen and the dining room.
Okay, so now you have your evidence of criminal behavior, don't you?
Yes.
Yeah, and you didn't call and attempt to get a warrant at that point, did you?
No, we did not.
No, you just decided you were gonna keep searching?
Well, we had not completed a protective sweep to see if there were any other individuals who might be in danger.
Oh, this is the protective sweep to
This-
find
this
out if
was-
there's people in trouble, right?
Yes, subsequent to finding the alcohol, we then conducted a protective sweep.
All right, and this protective sweep that you
Yes.
on, it didn't just involve looking into rooms for people, did it?
No, that's what it did. It was looking in each room to see whether there were any individuals.
Well, you
in-
said
in
you
each
went
room.
into one of the rooms, all the way in to look around and you found some drug paraphernalia.
Well, that drug paraphernalia was clearly visible from the doorway. It was not, it was not, the drug paraphernalia was not found by searching in corners, as it was out in the open.
Okay, so from where you were standing, you could
Yes.
see some drug paraphernalia, right?
Yes,
There's some more criminal evidence, isn't there?
yes.
And you didn't call for a warrant at that point, either, did you?
No, I did not
You
call.
made no attempts to get a warrant or to bring anybody else down to secure the house, nothing, right?
We did not seek a warrant or further.
And when you saw that drug paraphernalia, you could also see that there was nobody in that room that was in trouble, couldn't you?
True.
But you went in there and you looked in the drawer?
Yeah, in my experience, the presence of paraphernalia was likelihood that there was also presence of drugs as well.
Right, so you switched from looking for people to looking for more evidence.
This was the last last bedroom which we were searching, last room we were searching. So yes, at this point I did switch from looking for people on protective sweep to looking for evidence of illegal drugs.
Okay, and one final question. You did not see the people get in the car and drive away, right?
I did not see the people get in the car and drive away. That's correct.
I'm gonna stop there, thank you.
All right, anything else, 8A Lynch? No, Judge. All right, you can step down, officer, thank you.
Thank you.
All right, Commonwealth, 8A Lynch, do you wish to be heard?
Yes, Judge, I would just suggest to the court that in this particular situation, the police were certainly within their right to respond to a noise complaint in the area of the residence in question. When they were some distance away from the noise complaint, they did hear noise that would be sufficient to be a violation of the law. The officers were proper in securing the backup of other officers and approaching that residence. The officer, when present at that doorway to make an inquiry concerning the noise complaint, were properly within their right to be there. What is important in this particular case is, Judge, that when they approached the residence, they made observations of a number of motor vehicles that were parked at the residence. They knew that the individuals that operated that motor vehicle, based on the testimony from the stand, were minors, individuals who would be underage. And when they approached the house and they made a knock on the house and announced their presence, they did hear that the noise from the house subsided. So respectfully, at that stage, Judge, the fact that we have perhaps a party where there are underage people, and the fact that now this noise is down, perhaps there is no longer a concern for a noise complaint, but respectfully, there should be a concern of what's happening on the inside. The police are certainly within their right not to investigate crimes in certain situations, but to make sure they do their job as police officers and care for the community, to make sure that in situations like that, where there are perhaps underage people inside a house having a party that needs to be addressed, the police have a right to go in to make sure, in their function as community caretakers, that this situation is secure and safe. When the police entered that house, they did that for no other reason but to make sure the house was safe and secure. When the officers entered and made observations inside, they saw individuals at the back end of the hallway that were underage. They went further down the hallway, and then when they came into that larger room, they saw that there were a number of young people, minors, impaired. Certainly at that point in time, the officers now were presented with a situation where they had individuals who were underage who had, the evidence would suggest, had been drinking. Respectfully, at that point in time, the officers had the right then to fan out throughout the house to make sure that there was nobody else in the house, protectively sweeping the house, that perhaps had consumed alcohol, that was underage, and need of assistance. They did that proper, and when they presented themselves in different parts of the house, they made observations of things that they recognized as criminal, and when they made observations of those things, when they had the proper right to be there, and they recognized them as being criminal, they properly secured them. That being the alcohol, that being the drugs that were found in the adjacent room. As to the evidence concerning the individuals that were leaving the property, we would suggest that there has been sufficient evidence that there was the operation of a motor vehicle in a place perhaps where the public had access, the invitees or licensees, and that the individual was under the influence based on the observations that were made. As far as the individuals that were running from the house, the Commonwealth would suggest that there's some evidence, perhaps more appropriate for the case in chief, concerning perhaps a consciousness of guilt by the individuals that were named by the individuals that were spoken to at the house as running from the house with regards to the alcohol, and they should have all been properly charged as being minors in possession of alcohol. And again, the operator of the motor vehicle who attempted to leave the property should also be charged with the OUI, and the owner of the property who was in control of the house should certainly be charged with the possession of the marijuana.
All right, thank you. Attorney Hofmann.
Thank you, Judge. Judge, this is an outrageous search. The police had every right to go to this house and to look at the house. They could have looked in the windows. They could have done whatever they wanted. They had every right to be at this house. Unfortunately, once they knocked on the door and the noise level came down, and we stuck around for a few minutes and the noise level stayed down, they had no right to bother any of the individuals in this house. The minute that that officer turned that doorknob, he invaded the sanctity of that home and the privacy of all the people inside. Anything that happens beyond that should be thrown out, Judge. I'd like to suggest that there's several steps taken by the officer, all of which provided an opportunity for the officers to get judicial approval for further action. The first being, they open the door, they see people. They could have taken some action to get somebody to come to the door to them without violating further the privacy of any of the individuals in the house. They didn't do that. They walked in the house, they see a bunch of kids here. The officer told you himself he did not feel that it was an emergency. It's very clear that what the police were doing here was searching for evidence from the minute that they showed up at this house, and they were frustrated by the fact that they were not invited in by the occupants. They went further into the rooms and they found some alcohol. If they needed further evidence, they could have frozen the scene and gotten a warrant. They didn't do that. They go upstairs and they see the paraphernalia in the room. They could have frozen the scene, got a warrant. They didn't do that. The officer himself told you that at that point there was no longer a protective search going on, protective sweep, but he was actually looking for evidence, Judge. I would suggest that none of this evidence should be allowed to stand. There's no reason that the police officer should enter this home at all, but at the very least, that marijuana cannot go into evidence. The officer himself told you that he was searching for evidence and not conducting a community caretaking operation. Thank you.
All right, now I need your help. So we have the officer's testimony, which I found the officer's testimony to be credible. Did you?
Of course.
Sometimes. Well, he gave a fairly factual description of what he encountered, and he, I don't think, embellished what the facts were in this particular case. So we're always looking for that, because the credibility of the officer is going to determine, you know, the strength of the facts that I have to weigh. Because what I'm dealing with is trying to determine whether or not a warrantless search, right, no warrant, of a person's home was constitutionally permissible given these facts. So the first question is, was a search warrant necessary under these circumstances? I have to determine that. Then if one wasn't necessary, what is the lawful scope of the police search that's available to them within the confines of the law under this so-called community caretaking function? Because the police are out there to protect us from ourselves and from other dangers. So if they encounter us, whether it be out in the street or in our own home, they still have a responsibility to ensure that we are safe, and even secure in our own home. So they can't ignore that, otherwise they're not performing their obligations as police officers. So this case really comes out of an old Supreme Court case, and I was just taking a quick peek at it. The case is called Mincy, M-I-N-C-E-Y, versus Arizona. It's a 1978 case. And here's what it says. The Fourth Amendment does not prohibit the police from making warrantless entries and searches when the police reasonably believe that a person within a private residence is in need of immediate need. So they call this the emergency exception to the requirement of getting a warrant before they come into the home. So Massachusetts recognizes this doctrine, but based on what they call an objective test, and that's where I have to go. I have to weigh the evidence in gradation, in proportion to what the police did, to determine whether or not the police were investigating a crime. Because if they were investigating a crime, they can't use this community caretaking function as an excuse, as a pretext to go into the house and then say, oh, we were just here to make sure the occupants were safe, but in the meantime, taking a look around, opening drawers, looking in closets, looking all over the place. That's not proper, because that's not a proper scope of a search of this type of this nature, rather. And if there's not serious exigencies, meaning emergencies, that would justify this level of intrusion, then the police possibly exceeded the scope of what's lawfully permitted. So that's the context of what I have to look at in terms of the facts. So help me out here. Was this a lawful intrusion into someone's home based upon the facts that we have? Noisy party, right? Noise stops because they know the police are outside. You know, it's like the Three Stooges. Anybody home? No. You know, that type of thing. So they don't answer. But there's no, the noise law in Massachusetts, each town has a noise abatement law or a noise, excessive noise law. And I think Harwich, ADA Lynch brought this to my attention, has a law that says if the police audibly can hear what they feel is disturbing noise, whatever that is, and they have these meters that measure it based upon certain decibel levels, within 150 feet of you, then they have the right to issue a warning at first, and then it can gradate up to a ticket, a civil infraction of $150, and then if it doesn't abate on the third offense, they can actually proceed with criminal application for criminal complaint in district court. So that's our law in Harwich. But in terms of the facts of this case, they drive up, right? The door's unlocked, nobody comes to the door, they knock twice, no answer. Should they turn around and leave? What do you think?
Someone's got an opinion.
Yeah.
Okay, I think that they had the right to enter due to the complaint and the fact that it instantly got quiet.
Yeah.
But after asking if anyone was in danger, that like 3 officers were in the room and saw there was clearly a party. It was like, is anyone in danger? And then the like protective sweep then changed. The charges with the marijuana, those should have been dropped because that, I don't know, wasn't.
But a protective sweep extends throughout the entire house, right? There could be somebody upstairs in the upstairs bathroom that's
But
in
after
trouble.
the officer said that the protective sweep had changed, after he said that,
Yeah.
then I think that should have been dropped.
Okay.
And then the driver refused the breathalyzer, so I don't know. the OUI, I don't know, that one was iffy, but I think that the cops had the right to enter the house without
Right, well,
question.
clearly what we're talking about is this community caretaking function that the police have. They're out there to take care of us, right? Whether we're out in the street or we're in our own homes. So the police officer's justification for the intrusion in the home is, we want to make sure everybody's safe. So they come into the home under that pretext, and they look around, and then the officer, who's pretty good at this, quickly, just by looking at someone, knows that they're impaired. Did you catch that when he said that? Right? He knew that those persons were impaired. So he made the jump to light speed that these people are in danger of possibly going into an alcohol coma or whatever, and maybe that there's something that I should do to protect them under my community caretaking function. Is that what you were trying to suggest, A.D. Lynch?
I was, Judge.
Yeah, he was. And Attorney Hofmann starts out with, "This is outrageous." I've heard him say that before in Superior, but so help me out here. What am I going to do? You had your hand up. Yeah. What am I going to do? Am I going to allow this motion to suppress, which means that the evidence, we have two things. We have the alcohol downstairs. We have the drugs upstairs. What about the plain view doctrine? What's the plain view doctrine? Mr. Dickson told me you're experts on the plain view doctrine. What's that?
Someone can explain that.
You know what that is.
Like
What's the plain view doctrine?
Same site.
Yeah. Yeah. Exactly. The plain view doctrine is an exception to the requirement that the police aren't able to seize incriminating evidence, meaning that if you have something that's incriminating on its face in plain view, no need for any of this Fourth Amendment business. But if it's in your pants pocket or your jacket pocket, or it's in your drawer, your dresser drawer at home, or in the closet, can they come in and take a look? Yeah.
How do they prove it's in plain view when they search it?
Well, the officer testified credibly under oath, under the pains and penalties of perjury, because they can be charged with a crime for lying on the witness stand. It's called perjury. That he, when he walked into the room, saw on the bed 2 bongs and a pipe or something. I don't know what that is, but that's what he told me. And then he saw a partially open drawer and saw some marijuana sticking out of it, which later tested by the lab, and you heard A.D.A. Lynch go through that whole scenario, right? So he's saying, I saw it in plain view. So I believe that he did see it in plain view. But does he have the right to be in that position to make the observation? Because remember, the level of intrusion is only to protect the public, the community caretaking function. Go ahead.
So did this safety search start from the moment he entered the house? Like,
Sure. I would say that the safety search started the moment that he entered the house to make sure that the gremlins inside were safe. And then, maybe he should just check on that and leave. That's what Attorney Hofmann suggested.
So loud noise and a large gathering of cars is enough to suggest that people are in danger?
Well, the officer Dickson says, I put 2 and 2 together based on my training and experience. I know that young people who are in a house, in Harwich in the middle of the summer with loud noise coming, they must be doing something illegal.
They might.
I'm sorry, go ahead.
Wouldn't that be considered more reasonable suspicion than reasonable probable cause?
Yeah, I think it's almost like a hunch, right? The officers can't act on a hunch, because a hunch doesn't give them reasonable suspicion to then jump to light speed, i.e. probable cause. Go ahead.
If the door is unlocked,
Yeah.
is he violating the Fourth Amendment by opening the door?
Yeah, he passed through it. If the door was open, it's a different scenario. If the door was locked, and it doesn't matter whether the door was locked or unlocked. As long as they entered, they broke the threshold, they're inside without a warrant. So that doesn't really bother me either way, whether they opened the door unlocked or locked. If it was locked, it might have been a little juicier, because Officer Davis could just put his shoulder on it and break the door frame and come right through. Yes?
Is it against the law to not open the door to an officer or not answer?
Well, that's a tough question. The answer to that one is, quote, it depends. Because, if the officers believe that someone inside could possibly be in trouble, alcohol can get you in trouble if you drink too much, right? And someone's, and then let's say this, let's make it the most horrific thing we can think of, right? The officers come, they say, okay, the noise is gone, we're gonna leave. They leave, a half hour later they hear over the radio, fire, rescue, 911, emergency is needed at that particular residence, and someone's in a coma, they go to the hospital, they die. Alcohol induced coma. So now the police are saying, damn, we should have gone in, because our community caretaking function is such that our procedures are to investigate to be sure that the public's safe, then we leave. So that's what I meant about the scope of the search. The scope of the search here is limited. It cannot be an excuse for the police to go in to get criminal evidence to prosecute somebody. It can only be within the permissible scope of the community caretaking function. And that's what I have to decide on this motion to suppress. It's not an easy call. Yes?
Wouldn't the fact that the people inside the house would be lucid enough?
Well, I don't think so. I think I can argue against that and say just because the noise stopped doesn't mean that someone inside is not in trouble. They may have already taken enough alcohol or drugs to, to cause harm to themselves. So that's.
Doesn't that imply that the people inside are lucid enough to know that someone's in there?
Well, clearly it would be a stronger case for the Commonwealth if the noise continued or someone yelled out the door, if you got the guts to come in here, come on in. Because people get weird when the police show up. People like to challenge the police and they make it easy for the Commonwealth, by being combative and disruptive, and that's the easy case. This is a hard case, and it's a good one for the defense because there was compliance with the fact that the reason for the call was a noisy call. The reason for the call was only about noise and nothing else. The reason for the call wasn't we see smoke coming from the window or we smell marijuana. If we smell burnt marijuana, that could give a different twist to this. There's case law all over that. He would have pounced on that if he thought there was the smell of marijuana coming from the house. He would have been all over it. You have something you want to say?
If this officer didn't see the two people that left in the car, was it an officer downstairs or was it not until the other
Sure.
cop came?
What happens in these cases is that we have these things called objections. When the other side doesn't like a question based upon the fact that the answer might not be admissible under our rules of evidence, they can object. And I have to make those split-second calls about sustaining an objection. That means the answer doesn't come in, then it can't be considered. Or I overrule the objection, that means the answer can come in, it can be considered. We do this all the time in court, and we do it all the time in front of a jury. In this particular case, an officer cannot testify as to what another officer said or did. So that's why I sustained the objection. But had this been a more longer period than 15 minutes, and we got to get right back to court because all of us are due back in court at 2:15, and the judge is a real pain in the butt and wants them there at 2:15. And so we have to, we would have had another officer on the stand. We probably would have had the noise officer with the decibel meter, show up and testify too if we had the time to show it all to you. This is just a little snapshot. This is all good. You're helping me a lot. So what am I going to do? Am I going to allow the motion to suppress, or am I going to deny the motion to suppress? He wants me to allow the motion to suppress so that the alcohol and the marijuana doesn't come in.
Wow.
Yeah.
I think you could allow the alcohol and marijuana.
Okay. That's a possible scenario. So sort of half a loaf. Okay, you can't prosecute him for marijuana because you exceeded the scope of the lawful search because it was no longer it wasn't necessary to conduct the protective sweep in that manner. Okay, that's a good one. That's a possibility. Yeah.
Even if he opened the door, I don't think there was enough evidence that people were in serious danger, not enough to ask whether or not he could come in.
But doesn't he have the right to look around? You just open the door and just by osmosis figure out that everybody's all right. Don't you have to look around and check and see how many people are there?
You could have simply asked.
And what if they said no? Okay, let's take it that way. Can I come in? No. You got a warrant? That's a classic response we get.
And they didn't want to mention if they could see alcohol from the door up.
No, he couldn't see the alcohol from the door. He couldn't. And if he did, that might have given him more right to go in. Yeah. But he didn't. He's just there for this protective sweep, the community caretaking function. Those are all good points, by the way. I'm just challenging you. Go ahead.
So what if you
By the way, I don't get a chance to talk this much in court, so that's why I like it. I have to listen to these guys. And all I get a chance to do is say allow or deny. So I'm enjoying this. Go ahead.
So what if you put all the alcohol in the refrigerator? Nobody's tripping, nobody's throwing up. You say your parents are like alcoholics.
Yeah.
The police can't do anything about it, right?
The 30 pack of blood's not mine, it's my father's.
Yeah, well, I mean, if it's in the refrigerator, it's not really in plain view, and if nobody's really trashed.
Yeah. It's possible. That's possible.
Anything would change. If there was no visual impairment, when we say that would change the facts of the case as well. If there were no alcohol visible in plain view from that room, that would change the facts of the case.
Yeah. Go ahead.
I don't understand, like, in danger.
I'm sorry?
If you, like, see someone in view and they're in danger, I don't...
If you see someone, what? You gotta speak up.
In danger?
Oh yeah, if you see somebody in danger, someone's eyes are rolled back on their heads, the police officer's not gonna say, oh, he'll be okay, give him a cup of coffee and
get him some water
and let him sleep it off.
In this case, as an officer entering, I don't know whether or not someone's in danger. When I get to that room, I see people visually impaired. I don't see someone who I think is immediately in danger, but I don't know if this is everyone who's in the residence.
Right, there could be people
So
in the bathroom, there could be people in the basement, there could be people in the attic. Doesn't know.
But didn't you
That's right.
ask him?
They can do a protective sweep of the whole
Yeah,
house, yes.
but it doesn't mean I trust the answer.
They can do a protective sweep of the whole house, but they can't exceed the amount of intrusion necessary to accomplish the objective, called proportionality. They can only, if you will, search with this Fourth Amendment consideration, as long as it's not in violation. Yes?
I'm confused. So if someone comes to your house and they're like, the police come to your house and they're like, well, we want to do a protective search, you can say no.
Well, they have to have some justification for conducting the protective search. They can't
So
just
they
show
can do a
up
protective search without a warrant?
without a warrant, only in very limited circumstances, if they have sufficient justification to make an entry into a home without a warrant. Given these facts, with the noisy party business and the officer IDing some of the vehicles as belonging to underage persons that he knew, that's a key factor here. And the fact that there may be minors in possession of alcohol inside the house may give them the right, it does give them the right, to perform their community caretaking function and go in and check on the welfare and the well-being of the occupants of the home. But there's a limitation to that. So I'm going to take his suggestion. Alcohol comes in, I'm going to allow the motion to suppress with respect to the marijuana exceeded the scope of the lawful search. That's my decision. He'll take me up on appeal, because we have an appeals court, and we'll have new case law to give you some direction.
And I think you also had a ruling, if I recall from past years, on the OUI.
The OUI is going to be a separate case where the officers will be free to pursue the OUI prosecution in court, because the field sobriety test and the breathalyzer doesn't come in, but the field sobriety test gave them sufficient reason to then arrest the driver of the vehicle and prosecute him for operating while impaired. Okay?
Right. If we can give our panel a round of applause. Thank you all very much. These sheets, if you didn't finish yours, that's fine. Just finish it and bring it on Monday to class. Tuesday, since you don't meet Monday. But thank you all very much. Thanks again.
Oh, of course. Wait.